Hello and welcome to The Legal Scoop, our webinar series here at LOMAD where we discuss recent wins by our attorneys or our staff. And today I'm joined by Melanie Daly, who you're probably familiar with from the Daily Grind, who's going to talk about a recent win that she had. So say hello, Melanie.
Hi everybody, Melanie Daly here.
So I understand you had a recent win involving Section 44 apportionment. Why don't you just go ahead and give us just the basic outline of the facts of this case?
Yes, this was established for an occupational disease, repetitive use injury for the back. And at the time of permanency, which is when Section 44 is typically raised, the carrier raised the issue and essentially requested the claimant's Social Security records for all of his employments and also prior medical records. And the basis of that is to get start litigation on the date of contracture, which is different than the date of disablement. The date of contracture is the date where the disease process started.
Mm-hmm.
So essentially they want all of the carriers that are from that time to the present to be on notice for potential liability.
Okay, so now my understanding is, and you kind of already touched on this, is basically that like if someone's in the business that has developed their occupational disease, then we can get apportionment to prior carriers for prior employers, leading up to the date of disablement.
Correct.
Is that correct?
And it's based on the time that they worked in each employer. It's really comes down to a mathematical calculation, like if they are on notice or if they're liable between that date of contracture and date of disablement, then it really depends on how long the claimant worked for them.
Okay. Now, in this case, the other thing you need, right, is that every carrier that's potentially liable needs to be on notice before the issue can be fully litigated. Is that also true?
Correct. If there is a potential date of contracture that includes prior carriers, then they have to be present for that litigation in order to be able to defend their file on the issue of date of contracture, because there could be reasons to find an earlier date of contracture or a later date of contracture that might take them out of that range of dates. So they really all should be on notice, and they should be able to litigate to include the testimony of the doctors and testimony of the claimant.
Sure. So what happened here?
So here, the date of contracture was already set before all of the potential employers and carriers were on notice. That's one issue, because they were not even present at that hearing. And also, by the time that they were placed on notice, the 30-day period to appeal had already passed. So we appealed anyway because we weren't on notice then, and the board granted our appeal. And also the issue there was that they set the date of contracture based on the claimant's testimony and the lack of contemporaneous medical records. The medical records should have reflected an actual date that the disease process started, but that wasn't the case here. It was basically set on when the claimant started this type of employment.
That's great. So basically, in summary, our win here is that we were one of the carriers that wasn't properly on notice. We appealed the date of contracture finding and the apportionment finding, and it's now, I'm assuming, going back for further development of the record?
Correct. They rescinded that date of contracture, and they basically sent it back to the hearing calendar, and now it's the first carrier's burden again to produce not only medical evidence that is contemporaneous that shows that disease process, but also with the opportunity for all the carriers that could potentially be liable to be on notice and be able to litigate that.
That's fantastic. Well, congratulations. That's a great win. And I think anyone who's watching this, if you have a sort of weird Section 44 issue, which is pretty complicated, my recommendation would be to contact Melanie. So thank you for watching this episode of The Legal Scoop. Please subscribe to our YouTube channel for more content such as this and Melanie's show, The Daily Grind. And then you can also go to our website to become a member of our VIP program, where you'll get access to our newsletter and lots of useful information related to workers' comp defense. Thank you.
Thank you.